Good afternoon. We are privileged today to have giants of the present-day legal scene and giants of the historical field who can give us perspectives on both the present of our tumultuous Supreme Court and where the court and the crucial amendments that it's in the process of interpreting come from. Perhaps I can start the conversation today by asking Joan to spend a few minutes giving us a flavor of her marvelous new book, which I think it is fair to describe as a group biography that situates not just the high-profile decisions that many of us read about in the paper, but also the justices themselves in what has been a dramatic and unprecedented political moment. And then, by way of conversation, I'll ask both Joan and Eric some questions that flesh out some of the themes in the book and connect those themes to the past.
Thank you, Aziz. First, I want to thank Chicago Humanities for having this event, and Aziz, who I've shared a stage with before, and Eric, who I've always wanted to share a stage with. So I'm glad to be here, and also to thank some of I'm from the South Side. I'm from Beverly, so I'm glad to have some childhood and family friends from there, and my daughter who was at the University of Chicago with Aziz too. Why a group portrait this time? Dating to 2005, when I did my first Supreme Court biography on Sandra Day O'Connor, I always found it easy to sort of pick a very intriguing, interesting justice, try to bring him or her to life by tracing the narrative of their personal history and what was going on with the court. And I found, though, in 2019, as I was finishing up the book on Chief Justice John Roberts, I started to see something very different at the Supreme Court, which is what prompted me to go much more for a group portrait. And that was, frankly, the Donald Trump effect. As you see in the book, I show how the Trump administration propelled this court into a much more polarized approach behind the scenes. My specialty in these books has always been try to get as much inside the court, show what goes on in their private conferences, show how the justices are relating with each other. So when I first even got the contract to do this kind of a group portrait, it was late 2019, early 2020, and I thought my look at the court would be very much interior. I had no idea that I would suddenly have this outside story of the reversal of Roe v. Wade. In fact, I was one of those people who always said they will never reverse Roe v. Wade because the Republican appointees on the court will know what it will do politically to the country, which we've now seen what has happened in terms of both legal and political consequences. But I found that as I got to the Dobbs decision, and I made sure that my publisher was able to extend me more time so that I could include what happened in June of 2022, I realized that I had actually seen it coming, even though I didn't believe I saw it coming. I was someone who always thought that Chief Justice John Roberts was going to, in the end, be able to negotiate some sort of compromise, even though it certainly wouldn't have pleased all abortion rights advocates. It would have stopped short of completely reversing a half century of abortion rights. But that's just to say that all the pieces that led to the culmination of the reversal of Roe v. Wade had been laid before, and not just with the Roberts Court and with the presidency of Donald Trump, but before then with, for example, the Ronald Reagan emphasis beginning in the 1980s. So that's kind of, I found that my tale of a broader look at the justices was just right for this time. And I'll just give one brief example of something I discovered and that I try to unspool with the book, and that has to do with the really entwined set of circumstances with Ruth Bader Ginsburg's death, who Aziz once worked for, Ruth Bader Ginsburg, on September 18th, 2020, and the culmination on June 24th of reversal of Roe v. Wade. And I found it just so intriguing that the state of Mississippi that was defending its ban on abortions at 15 weeks had actually gotten all its filings into the court at a time when she was still alive. And if the justices had considered it, the case, while she was alive, they might not have taken it up, because at that point in the court history, they were not re-examining bans on abortion because they realized that it would conflict with Roe. But upon her death and the succession of Justice Amy Coney Barrett, everything changed. And I have an anecdote in the book that I thought was symbolic of what happened then with the law. Within days of Justice Ginsburg's death and then her memorial service, her staff got a call from Chief Justice John Roberts' top aides and said, you have to move out of her chambers immediately. You have to move everything out of there. They said, move down to this windowless theater space on the ground floor, take all her possessions and sort through them there. That was very upsetting for many people at the court, irrespective of how they felt about, how close they were to Justice Ginsburg. It just seemed to shatter the normal protocols. But it showed how the administrative staff at the court felt that it was a real fait accompli that Trump's third choice of justice, Amy Coney Barrett, was about to move in, and she was about to be swiftly confirmed before the November election. And it wasn't long after that that one of the overriding legacies of Justice Ginsburg, her work on reproductive rights, was then similarly sort of cast aside with the Dobbs ruling in June of 2022. And one thing I trace in the book is how that all came to be and how some of the liberal justices actually felt like they were misled at various points by Justices Kavanaugh and Barrett in terms of how they were going to go. And also I trace the consequences of the leak. The Dobbs case was heard in oral arguments in December of 2021, right on the heels of the Supreme Court's action on Texas's SB 8, as some of you might remember, which was the 6-week ban. And after the justices heard that case, the Dobbs case, it was, again, following on the heels of their approval, their narrow approval of the Texas law, they gathered in their own private conference. And rather than just approve of this Mississippi ban on 15 weeks, that's when a 5-justice majority decided we want to go all the way. We don't care what anybody's presumed about the half century of reproductive rights that was Roe v. Wade. We want to completely reverse it. And Clarence Thomas, who was the most senior justice, had the majority. He assigns it to Samuel Alito. Samuel Alito starts writing this very muscular opinion against Roe v. Wade. And by February 10th, he is done with his first draft, which was a very quick turnaround. And that's the draft that ends up getting leaked on May 2nd, just about a year ago, right around now, is when that got leaked. And one thing I say in the book is that I don't know who leaked it, but as an aside, I do not intend to go to my grave not knowing. I will want to find out. People eventually talk. But I can tell you that I don't know who leaked it, but I know from talking to justices what the effect of that leak was. And it basically locked in those votes so that Chief Justice Roberts, who was desperately trying for institutional reasons, legal reasons, probably even some political reasons to make sure that Roe v. Wade was not overturned at this point, that he was unable to make any more headway once that was leaked. So those are some of the dramatic high points that I try to show in this book, in addition to something that both Aziz and Eric are so steeped in, the democracy challenging rulings, for example, in voting rights, just where the court has been going over the years in terms of rolling back the protections of the 1965 Voting Rights Act, where they might go even further on things having to do with state legislature power, brushing aside state court power for elections. But those pieces are all in there. And what I hope to do, and what I hope many of you see when you do read the book, is that I try to explain these big decisions that will have such a consequence in all of our lives through the internal characters and how they deal with each other and the internal pacts that are made between justices and how, frankly, sometimes switched votes, sometimes not switched votes, impact the final rulings.
Thanks so much. Perhaps I can ask Eric to briefly reflect on his perspective, either historical or otherwise, on the kind of tumult that Joan just described, and then I can ask some questions of the two of you.
Yeah. Well, first of all, let me thank the Chicago Humanities for inviting me to take part in this conversation. I'm very happy to be here. And I will second the idea that it's a fascinating book. It's very, very well written, well researched, and definitely worth reading by everybody out here. I think actually you highlighted some of the things that you tried to accomplish that I think you very successfully did in terms of mixing together or melding the character and the opinions of these justices with the detailed history of these important cases over the last few years. You know, sort of where they come from, what the court is really deciding. Often news reports don't give you a clear picture of why a particular decision may be important, not simply because of its own, you know, what it decided, but how it fits into a much longer pattern, which really has been going on. You mentioned Reagan. I think you can take this back to Nixon, really. The conservative effort to reshape and control the Supreme Court. I, like many other people, grew up in the era of the Warren Court. And we were, you know, it was just sort of second nature that the Supreme Court was the most liberal part of the government most of the time, and that the Supreme Court under Earl Warren was sort of trying to clean up some of the problems of American society that the other branches of government had sort of failed to really deal with. And so when people felt their rights were being denied or equality was being denied to them, or wanted to expand the definition of citizens' rights, they felt a lot of confidence going to the Supreme Court. Not that they won every single case, but that this was a court that was sympathetic to basic principles of democracy, liberty, individual autonomy, etc. Starting under Nixon, really, I think that this concerted effort, which produced, first of all, organizations like the Federalist Society and others devoted particularly to changing the nature of the federal judiciary and making it much more. Originally, what really riled them up was not so much decisions about abortion or even voting rights, but economic measures, economic decisions. They wanted to cut back on the regulatory power of the federal government when it came to the behavior of corporations and everything. Of course, this is a long story in American history I don't want to go into right now, but you know, Lewis Powell wrote a famous memo around 1970 calling on, it was for the U.S. Chamber of Commerce, calling on business people and conservatives of various kinds to sort of join in a battle to take back the judiciary. And more than that, a battle of ideas. He was very concerned that the young in this country were developing these sort of anti-capitalist or pro-democratic outlooks. We know the 60s was a pretty volatile time, including in Chicago. You know, Powell eventually got on the Supreme Court, and one of the hidden, I think, purposes of these 6 justices now is to really reduce the regulatory state. That's not as sexy a subject as voting rights. It's not as important to individuals' life experiences than whether they still have the right to control their own reproductive lives. Does anyone really care what the powers of this federal agency or that federal agency are? Well, yeah, a lot of people do. They just don't happen to be the ones we hear about most of the time. So there is, you know, but my point, to go back to the book, is that it gives us both the history of this that has culminated in this supermajority on the Supreme Court, and as we heard, the character, the training, the outlook of the people who are on the court and were on the court until very recently, like Justice Ginsburg, et cetera. So it's a very interesting way of looking at court decisions. And one other thing I want to emphasize is, I don't know that this was your purpose or not, but I think one thing that people can take away from the book is the need to demythologize the Supreme Court. Now, the court is doing a pretty good job of that itself. Public opinion polls show that public respect for the Supreme Court has diminished radically in the past 4 or 5 years under this conservative majority. But I think when we think of the Supreme Court, and maybe it's just an age thing, I myself can't quite get out of my mind the idea that the Warren Court was what the Supreme Court really is all about. The fact is, the Supreme Court was supposed to be the most conservative branch of government. It's not. It's an undemocratic institution. People are not elected. They serve for, their entire lives. But what you get here also is the back door, horse trading, the way in which people swap votes. In other words, Justice Roberts' famous comment that the role of the judge is just to call balls and strikes. No, the umpire in baseball doesn't make the rules about balls and strikes, which he then goes on and enforces. So I think this book will help us, whatever our political views, maintain a candid view of what the Supreme Court is and isn't, and maybe in that way realize that, in my opinion, many of their decisions do not deserve the respect of people who are interested in democracy, individual rights, etc. And no matter how exalted the Supreme Court is, and particularly in its own opinion nowadays, we have to realize that their views have their decisions have great import, but they don't deserve intellectual respect, in my opinion, much of the time. And this book helps us understand why.
So can I build up on both of your comments by bringing out a theme that's richly woven into Nine Black Robes, and that may be a provocation both for you, Joan, and for you, Eric. The theme is the role not just of the in-chambers and in-court deliberations, but the way that the court is nested into a larger political context. And you have a marvelous account in particular of the role that Don McGahn, who was the President Trump's lawyer, played. And you touch upon the role that's played by the organization that Eric mentioned, the Federalist Society, which was founded in the early 1980s at the Yale Law School as a place for conservative voices, precisely in reaction to the Warren Court. And the question that I want to, or the provocation and the way to frame that element of the book might be this. Is the story that you're telling a story of the Trump court as opposed to what we might imagine a Cruz or a Kasich court might have looked like? Or is the story that you're telling the McGahn court, the court that the Republican legal elites, the people who were in the Beltway, circulating among Republican administrations, is this the court? Is that the context we should understand the court in? Or is this the Leonard Leo court? Is this the court that the organizing efforts of right-of-center organizations, well-funded by a number of large donors, networked into broader tapestries of think tanks, interest group mobilization or interest group organization, and well-funded lawyers? Is that the court that we have? How should we think about the story that you're telling in light of what's going on, not just in the backrooms of the court, but as you marvelously detail, going on in the backrooms across the Beltway?
Those are all very good questions, and just a first of all, the answer is going to be a little bit of all of the above. But one thing I want to say in response to Eric's point about my sort of taking the court down into sort of the ground level from its, exalted place. I have to say, this is my fifth book. And usually I sort of know what I'm saying, but I have been surprised at how much is that I wrote that I didn't quite realize I was writing. A couple of reviews, and I would say Sam Tannenhouse in the New York Times, and then Carlos Lozada in a separate piece in the Times that compared it to the Brethren and talked about themes that I knew in a general way I was doing, but I didn't see the precision that they observed. And the precision that you've just observed, sometimes, the author is laying out a truth that she sees, but she's still thinking of herself as quite an institutionalist, which I do think of myself that way. I have the same sort of idea of, you were there for the Warren Court, I came on the heels of the Berger Court and the Rehnquist Court, and, certainly had a reverence that I hadn't realized I was compromised, that I hadn't realized my own view had been compromised as much as it had. But one Post-it that was up on my desk, I'd say it's been up on my desk for the past 4 years, is that things have gotten so serious in terms of the rulings that I really should stop doing more featurey stories, which had been kind of one of my stock and trades back to the Washington Post. I always loved to kind of give some slice of life things. I'm sort of beyond the slice of life. I'm just into kind of the consequences. And that's all to say that I do feel like this is a different court, and I somehow was able to characterize it that way as I was writing, even though I hadn't realized my own evolution in seeing it differently. And then to the outside forces that Aziz just mentioned, there's a chapter called The Triumvirate, and that focuses on Don McGahn, who was White House counsel, a name that many of you wouldn't recognize right off the top, but he was a man who was a lawyer in a hotshot firm in Washington, D.C. He's always been an anti-regulatory figure who, certainly worked very hard to get rid of campaign finance regulations. And he, to the point about economic changes at the court, really wanted to choose justices who weren't just part of the culture wars and move the court in a different way, in terms of religious liberties for conservatism and anti-abortions, but also he was interested in picking jurists who would get government regulation out of Americans' lives. I mean, whether it be for public health, safety, vaccines, whatever. And he was quite successful on that front. But he really worked hand in hand with Senator Mitch McConnell for the triumvirate. Senator Mitch McConnell, who we all know, the Republican leader, who obviously kept open the Scalia seat that President Obama had tried to give to Merrick Garland, and then who also, worked very hard to get Amy Coney Barrett on the court in a matter of weeks, in contrast to holding open the Scalia seat. And then the final person is Leonard Leo, who has been a leader of the Federalist Society. Those three figures all worked very closely together to carry out the Trump agenda. Now, would that have been like a Jeb Bush agenda or a John Kasich agenda or a Ted Cruz agenda? I think Donald Trump was more willing to turn the whole thing over. And look, Donald Trump specifically ran in 2016 on the court, on the Scalia vacancy, and said, I will appoint only justices who will reverse Roe v. Wade. And lo and behold, he did it with these handmaidens of sorts to get it done through the Federalist Society. So I think to answer your core question, this is a court that was produced by this particular president with this supporting cast. And as Don McGahn himself said, it's not like Donald Trump outsourced his search for justices to the Federalist Society. He insourced it. We are in the castle. And Don McGahn, who's only, I think, what was he, born in like 65, 66, relatively young in this whole world, he had a mission. He talked a lot about how the Thomas hearings and Bork hearings were very motivating for him to try to get revenge of sorts. And that was certainly a Mitch McConnell. Mitch McConnell always said, you'll rue the day that you voted down Bob Bork, and they are now in charge, or were in charge.
Eric, can I bring you in here and maybe sharpen the question by asking whether anything has changed since the period that you're an expert in? So the post-Civil War period is a period in which there's tremendous change to the powers of the federal courts. It's not just the Reconstruction amendments get passed, but there's a number of very, very important measures that expand the powers of the federal courts. And then toward the end of the century, the actual apparatus of the courts gets deepened. How did the president's lawyers, the networks around the presidents think about the court then? Did they instrumentalize it for the same in the same way that we're seeing today, or is our period of everyone makes the mistake of thinking their own period or moment in history is unique? And you're here to remind us that it's not.
Yeah. Well, it's hard to, I was about to say to remember. There's no one here who can remember the Supreme Court of that era. But to just grasp the fact that if you look, let's take the United States in 1865 when the Civil War ends and slavery is abolished and gigantic questions about human rights, citizenship, and political power have to be resolved. The victorious Republican Party couldn't have cared less about the Supreme Court. In other words, the Dred Scott decision had completely destroyed the reputation of the Supreme Court in the eyes of anybody who cared about the slavery issue. Even Abraham Lincoln, who was about as mainstream a lawyer as you could get in terms of, he wasn't one of these abolitionists like William Lloyd Garrison, who burned the Constitution at an abolitionist meeting because of its protections for slavery. Even Lincoln said, the Dred Scott decision is wrong and we are not going to abide by it. It's hard to imagine a president exactly saying that right now. Each of the three constitutional amendments, 13, 14, 15 of Reconstruction, end with a section saying Congress shall have the power to enforce this amendment. Not the Supreme Court. Nobody said, let's see what the Supreme Court has to say about this. Maybe the Supreme Court can contribute something to our Reconstruction policies. No, they didn't want to hear from the Supreme Court, and they wanted Congress to have the power to decide what sorts of policies were going to be implemented in order to deal with the consequences of the Civil War. And as time went on, I think the problem, was, among others, that the commitment to equality in the North waned. There was violent opposition in the South to the Reconstruction governments, the granting of the right to vote to black men for the first time in any significant numbers and things like that. But there was also a retreat, and the Supreme Court reflected that retreat in the 1880s, 1890s, early part of the century, in a whole series of decisions, most of which are still out there, have never actually been overturned. But, Plessy v. Ferguson was overturned in the Brown case, at least as far as education was concerned. Many other terrible Supreme Court decisions of the late 19th century are still perfectly good law, and efforts to overturn them have not gotten anywhere. But so my point is really to go back to the Reconstruction. The architects of that policy, trying to make this into a more democratic society of equals, their view of the Supreme Court was it was just an obstacle to creative policy, and they didn't really want to have much to do with it.
Thank you. Maybe I can ask Joan to elaborate some of the themes on her book in relation to some news stories that have followed certainly the moment that she finished the book, if not its publication. Let me offer. I'll offer a first question that has that flavor, and then there'll be a second one that has that flavor. The first is about the series of stories about relationships between the justices and other figures in the political world. Probably the most high profile of these that I'm sure many people here have read about are the stories about Justice Thomas in relation to Harlan Crow. there was also recently a story about transactions between Neil Gorsuch and a figure, a Colorado-based political operative or a political figure who went unnamed in his financial disclosures. And then I think this week there was a story about the representation on the part of Jane Roberts, who is the spouse of Chief Justice Roberts, of several lawyers or figures in law firms who have business before the court. And I think there's two readings of all of these stories. One of them is that the world of Supreme Court justices and elite lawyers is a pretty tight one. These are people who are friends. They all send their kids to the same schools. It's not particularly surprising. They go on holiday together. It's not particularly surprising. There are these transactions between people who are in the same circles. The other is that this is evidence of a profound ethical problem. The Senate obviously will not hear from Chief Justice Roberts next week, but nonetheless they'll have some sort of a hearing, which warrants some kind of more careful scrutiny of the role that the court plays and the way that it is shaped not just by the formal filings before it, but by the informal networks around it. And I wonder how you read these stories in light of your deep knowledge of the court.
Yeah, and all three are a different degree. I would say that the one that has been most troubling to people is Clarence Thomas taking these lavish trips on the dime on the millions of Harlan Crow, a mega donor on the Republican side, who has actually worked very hard to try to change the judiciary in various efforts. And I think that what it does is it casts a spotlight on the fact that the justices themselves have declined to adopt any kind of formal ethics code. They say they follow the guidance in the rules that lower court judges have to follow. But the truth is that if you have some complaint about the fact that a justice has not recorded any of these kinds of transactions on his or her financial disclosure forms, there's really nothing you can do about it. You cannot, once somebody becomes a Supreme Court justice, there's no grievance process, there's no resolution process. In fact, if there are complaints filed against a lower court judge who is about to become a justice, as in the case of Brett Kavanaugh in 2018, when there were many complaints against him because of his comments during the confirmation hearing, they all are dissolved automatically the minute he becomes a justice. And the reason I think a lot of these concerns are being raised now is because there's a sense of a lack of accountability on the part of the justices. And I do not think they get that part. I think that the chief really, I do think the chief has wanted to have some sort of more formal statement on ethics, but he can't do it as he can on cases with a 6-3 vote. You need to be unanimous. You can't say those three guys aren't going to abide by this, and so he has, I will not minimize the task that he has in front of him, but I also would say that I think part of Chief Justice John Roberts is just hoping this will all blow over as other incidents have. But I think the reason that these episodes are more salient now is because the public, as certainly polls bear out and certainly public commentary bears out, is that there's a real suspicion on, how much regard do we give to the court in this moment when the majority is willing to roll back precedent, where the majority is willing to be conservative activists. The original notion of conservatism, even in Lewis Powell, who Eric rightly mentioned, was, part of the mastermind of this kind of more economic revolution. Lewis Powell was a real moderate. When you think of back to the Nixon conservatives, Harry Blackmun, Lewis Powell, Warren Burger, even in contrast, Rehnquist not. I think Rehnquist would easily be comfortable with this majority now. It was much more of a mixed bag than you have today. So I think these ethical concerns that come to the forefront, first of all, they're very easy to understand. You don't have to figure out, people get it. People get the fact that they've heard Clarence Thomas talking about going around in an RV, and he used to talk to me all the time about how he loved to go, to the Midwest and Nebraska, travel in RV, and he said, I take seriously the flyover country that other people minimize. Well, as I said to Aziz, I wish I had known to ask about the private jets and super yachts. I didn't at the time.
He also said he loves to, after his yacht cruises, he loves to go to Walmart parking lots,
For the
right,
RV,
and meet with regular people.
Yeah.
Now, this is a justice of the Supreme Court. What is he saying that he thinks about other people in this country? We don't have a constitution for the regular people, and it has no bearing on other people in this country. But he just, he's willing, ever since he got on the court, to just put out outrageously insulting, often, comments. In fact, just to pick up on one of the points you made, I don't know if you intended this, and maybe it's my own predilections, but your little mini biographies of these people, very well done. It makes them seem rather unpleasant, frankly. I mean, really, would you like to have dinner with Gorsuch or Alito? I mean, these people are constantly, look at Alito just the other day, attacking members of the court by name, because of, and also just yesterday, right, saying he knows who leaked the opinion. He won't say anything, but it's certainly not one of the conservatives, which limits the number pretty dramatically. But you say in the book, I think it's a very shrewd comment, that Alito has a kind of constant sense of grievance.
Yeah.
He constantly feels he's being somehow not taken seriously, or not listened to, or whatever. What, the guy's on the Supreme Court. Well, what is his problem? Why is he so full of grievance?
People have given me, some conservatives have given me a hard time for another phrase in the book is that he wears a cloak of grievance. Mm-hmm. And I thought, I really felt that. But just in the last 10 days, he's made that so much clearer that he does, his dissent to the medication abortion drug case just had grievance and complaint and against everyone in it. And then what Eric is referring to is yesterday the Wall Street Journal published a interview that Justice Alito had given to two people who write often, one who's on the editorial page there, where he complained that, first of all, he feels that they're such victims because of people protesting at the House. And of course, it's very real that somebody did go to Justice Kavanaugh's house armed, thinking that he could do his family harm. And that's something not to be minimized. But Justice Alito just feels like they're the ones under attack, and that they, as Eric said, on the leak, he said without any kind of evidence that he knows who it is. And if he knows who it is, I don't know why the court didn't say more when it issued its report saying, we don't know who it is. And also his conclusion that it must have been a liberal, not a conservative, when it really served the conservative side.
I was going to ask about the Danko opinion, which you just mentioned, and maybe I can just push you a little bit on Alito in particular. So the opinion that he issues in the medication abortion case, which is called Danko, which is a dissent from the court's decision to stay Matthew Kavanaugh's quite extraordinary ruling enjoining nationally the provision of mifepristone on a variety of quite extraordinary legal grounds, including the Comstock Act from Eric's period. Your history lives, at least in the North District of Texas. Thank you so much. The Danko opinion doesn't just have the kind of personal attacks, remarkably, not just on his liberal interlocutors like Kagan and Sotomayor, but also against Amy Coney Barrett, who he criticizes for hesitancy about issuing stays, and then goes on to make the most extraordinary statement with respect to the unwillingness or incapacity of the Biden administration to follow the law.
Right.
So I noticed the cloak of grievance language in the book, but I wonder whether you could reflect upon where this newfound willingness to express a kind of politics of victimhood comes from. There was the moment in his confirmation hearing when his wife walked out. There was the moment in, I think it was the 2010 State of the Union address.
When he
which
said not true as President Obama was speaking.
I was mouthing there, you just didn't see me.
Oh, sorry.
I didn't mean to offend you.
As long as you don't repeat what Mayor Daley said at the Democratic Convention to Ribicoff, I don't think that's allowed here.
Okay, no. Where is this coming from? What is Sam Alito's deal?
It's so interesting, and just to remind everyone what the Mifid-Prustone decision that came out just about a week ago, when the court ruled in Dobbs, the majority opinion, even by Samuel Alito, said, we're returning it to the states. And Justice Kavanaugh, who wrote a concurrence, I think apparently the fifth vote in that, said, we're not making abortion illegal nationwide. It'll still be up to the states. But if people don't have access, no matter how you feel about the issue, if people don't have access to medication abortion, which is the main way that women do end pregnancies these days, then it really isn't lawful in even the states that want to make it lawful. So it's got very much practical consequences. And as to what's happened to Samuel Alito, I do think something's happened. I do think that he has changed through the years. He always was a little bit sour about things, but you're right that his anger is directed to his own now too. There's an important case that came out in 2020 called Bostock, where by a 6-3 vote, in an opinion by Neil Gorsuch, a conservative, the justices expanded Title VII of the 1964 Civil Rights Act to cover workers who face discrimination based on sexual orientation or their gender identity. And that was a solid 6-3 decision, and Neil Gorsuch was one of the dissenters. And Sam Alito was one of the dissenters, and he was so angry with Neil Gorsuch. He was angrier again with his own, and that's why with him attacking Justice Barrett, and that wasn't the first time in this. And you wonder why? Why does he need to do this? Because he does undercut himself. And then the point that to say the Biden administration has never said it will not follow a court ruling. In fact, its spokespeople have affirmatively said, we will follow the courts, even though some more liberal Democrats have said, maybe we shouldn't follow this. The Biden administration has said, we will follow, no matter what. We will follow. We were going to appeal these decisions, but we're going to follow them. And then for him to write in a court opinion, in an opinion, well, I can't believe them, is just strange rhetoric if you want to be seen as someone who is above the political fray.
Yes, let me. But that kind of language and I don't know, just extremism has been around for a long time. Let me just briefly tell you a little story about Justice Rehnquist. Mm. He wrote a book in the early 20th century called The Centennial Election. Probably nobody here has read that book, and if they have, it's a waste of time. It has no historical validity whatever. It's about the election of 1876, which led to a compromise that ended Reconstruction. It's really a defense of Bush v. Gore, where he basically says, look, members of the Supreme Court chose the president in 1877, we should do it again. But the point is that, to me, as a scholar of that period, and knowing how mythologies about Reconstruction have underpinned racism in this country for a long time, that Reconstruction just proved, quote unquote, that black people are incapable of taking part intelligently in political democracy. And in his book, Justice Rehnquist, the Chief Justice of the United States, says, after the Civil War, the North imposed a Carthaginian peace on the South. What is a Carthaginian peace? It's where you try to destroy the entire society, not just have a peace treaty ending the war. Rome sort of decided to destroy Carthage after they defeated them. what is the Carthaginian peace? It's granting rights to black people. The Chief Justice of the United States believes that giving rights to black people is a punishment to white Americans. And you, even today, 20 years after that book was published, you still hear that in conservative circles, that, you know, the real victims here are white people, and black people should just stop complaining and stop going to court and that sort of thing. So this kind of, as I say, extreme language has been around for a good while, and Alito is not the only one who has been using it.
Maybe I can ask one last brief question before we turn to audience questions. We've talked a good deal about the influence of the larger political environment, of the conservatives, but maybe if you could say a word about those who tend to be the dissenters on the court. You note in the book that Elena Kagan started out her career at the court trying very much to be a conciliatory figure. You talk about how she tried to do this particularly in cases under the First Amendment's religion clause. You mentioned that this perhaps has not played out as she might have hoped over the last 2 years, as the religion clause jurisprudence has become much more conservative, much more hostile to accommodations between religious and secular interests. Where are the liberals on the court now? What cards do they have left to play now that there are 3 of them rather than 4?
Yeah, it's not a grim prospect for them. Justice Elena Kagan, product of New York and taught at the University of Chicago, she was, in fact, she was President Obama's second choice, and she was not seen as a super progressive individual. You know, she was somebody who was willing to work the center, worked very much with Justice Breyer, who retired last year, and worked with the chief a lot. She has tried to be a partner to the chief, but now it's not, you know, that's exactly not a way to go, because he's just one vote where she would need 2 to get any majority. And I think what you're going to see from her is many more dissents where she's as vocal as Justice Sotomayor. Justice Sotomayor always would call it as she saw it. She was the one who would outright say Donald Trump is a racist, listen to what Donald Trump is saying. She wouldn't want to sugarcoat anything the way Justices Breyer and Kagan would, and even to some extent Justice Ginsburg. You know, Justice Ginsburg did buy into a little bit of the decorum. You know, she didn't want to outright, you know, take any personal shots the way that it's becoming more and more common on the court. But their options are really few, and I think what you're going to see is them trying to talk to the public more. And as much as I have quoted scholars saying that this court is essentially the court we're going to have for the next 50 years, given the ages of the justices and strategic retirements, that we will probably have this kind of far right. And sometimes people say, oh, well, she always uses the phrase far right. Why isn't she saying far left? Well, this is far right. When you compare it to even the Rehnquist court, these justices on these conservative appointees are different from Justices O'Connor and Kennedy, Lewis Powell, people who we've mentioned before who were true conservatives. But anything can happen. I mean, just think in 2016, I am sure people like Sonia Sotomayor and Elena Kagan really thought they were suddenly going to get a 5th liberal when Justice Scalia died. That was not to be because of Mitch McConnell. But you just never know what can happen. So maybe that's what they cling to.
Let me just say one word about Sotomayor, who I admire enormously, partly because my wife grew up 10 blocks away from where Sotomayor grew up, Bronx, Washington Heights area. But I respect her calling a spade, so to speak, when she, in her opinions, because there is no, as you point out, there's no way that she's going to be able to influence the majority now. So why try to be conciliatory? Why not, in a sense, be like the John Marshall Harlan of the moment, where you put out your dissents for future generations? And maybe if the country becomes a little more sane, then they'll have a new Supreme Court, which will go back and say, well, look at this dissent, how it actually makes much more sense than the majority opinion in this year. She's creating a jurisprudence which sort of is like a pinch hitter at the moment, but maybe in the future will become the majority. At least I hope so. But as a historian, I'm not a lawyer, law professor, or anything like that, but I sometimes get invited to talk at judicial circuit conferences. And there was one where Justice Sotomayor spoke to a large group of lawyers and people. I asked her, she had I don't remember which case this was, but she had become the first person ever in the Supreme Court to quote W.B. Du Bois's great book, The Souls of Black Folk, in a dissent. Mm-hmm. And I said, why did you quote that, that great book by Du Bois? It's not a legal treatise. It has nothing to do with law, really. It's about other things. And she said, I just think my colleagues on the court need to know how society actually operates. That's a good motto for the Supreme Court. One of the things that I think is most reprehensible about them today is they never consider the consequences of what are the consequences of denying the right to an abortion to millions of women? In terms of their lives and their livelihoods and things like that. What are the consequences for society of saying that everybody in the world can carry a gun and, no matter where you are or, that kind of thing? She wants them to think about the real world, which unfortunately a lot of them don't seem capable of doing right now.
I think it's the moment to turn to audience questions. And while that I know takes a second to happen, just to flag, lest we sound too pessimistic, it was the case that the first Justice Harlan's rulings in time became the basis for much of the jurisprudence of or at least with respect to race, right, much of the jurisprudence of the Warren Court. So it's not necessarily for nothing that these dissents are written. So my understanding is that we have about 15 minutes for questions. But unless the lights are raised slightly, we are not going to be able to ask them because I can't see anything.
Right.
So I will wait for a second. I think that's the right thing to do.
Yes, beautiful. Thank you. Folks, if you have a question, please raise your hand. Wonderful. And a staff member will come around with a microphone. Oh, yeah. We do ask that you keep it to questions only. Try to keep commentary to a minimum and to make your questions brief and clear for ease of communication with our panelists.
And I'll cut off people if they have long questions.
All right, well, your first question is right over here about mid-house to your right.
Hello, thank you very much. Could I get your opinions on the influences or non-influences of the spouses of the Supreme Court and the history of the Supreme Court? And of course, I'm asking about your positions on Clarence Thomas's wife, Ginny Thomas, who is an out-and-out reactionary right-wing, we all know this, and has probably influenced a lot about January 6th.
Well, as I was writing this book, one thing that did come out about the Thomases were the messages that Ginny Thomas had written to Mark Meadows, who was then, chief of staff to Donald Trump, saying, we got to do something about this. We got to get these election results reversed. They're really, Biden didn't win, Donald Trump won. And, it was a real issue that Clarence Thomas was sitting on election-related cases as his wife was doing that. We tried to get any kind of comment out of Justice Thomas about why he felt he shouldn't recuse himself from cases when it was so clear the role that his wife had played. He didn't say anything. Chief Justice John Roberts didn't say anything to that. She testified to the January 6th committee saying, my views are my own, we're in separate lanes. They probably do have their own same, similar views, and they've been probably mutually reinforced implicitly, if not explicitly. But that is something that certainly the attention that has been given to Ginny Thomas and potential conflicts of interest, I think, do spread to the other justices' spouses. And as Aziz just said, John Roberts and Jane Roberts are probably sitting back saying, why us? Because they probably feel that they shouldn't be in the spotlight the same way as the Thomases, but Clarence Thomas certainly is not conducting himself any differently because of all this attention.
Yeah, I'm reminded of an opinion that Thomas wrote in a case called, I believe it was in Lawrence v. Texas, in which which is a case in which the court strikes down a same-sex sodomy law, where he starts the opinion and says, this is an uncommonly silly law. And it's almost impossible to imagine him saying that today.
You know, that I'm so glad you brought it up, because I was actually just thinking of that case for unrelated reasons to today's panel. But in that, if I'm remembering right, Aziz, doesn't Clarence Thomas say that if he were a legislator, he wouldn't have voted to ban same-sex relations? You know, it was reversal of Bowers v. Hardwick. He was saying this is not the role for a judge, but he personally sees why same-sex couples should have the liberty to engage in intimate relations. And that, I thought that was a really striking opinion, as I'm remembering it, because he separated himself from, for example, Antonin Scalia, who, was just compared gay relations to all sorts of horrible things. And, Clarence Thomas, once upon a time, did show those kinds of things. But that's interesting that you think in today's atmosphere, he would not deign to even try to cross the aisle in a modest way.
Hardly. He went the other way, as you know. Kavanaugh, wasn't it Dobbs, said, look, don't worry, we're not going after Griswold, we're not going after all these other things, gay marriage, no, don't worry. But it was Thomas who said, in his opinion, no, we're going after the privacy cases. This is just the first step, folks.
That's right.
Use of contraception, better go to the drugstore if you want that, folks, because they're going to outlaw it soon. But, he's not willing to give an inch at the moment.
Could you please speak about Anthony Kennedy, his mindset and retirement that obviously put his landmark rulings at risk?
Yeah, I can address that briefly, and I don't know if Erica wants to join in if you knew Justice Kennedy in any way. When he retired in 2018, he was already in his 80s, and as I portray him in the book, he was starting to be weary of the whole thing. And he hasn't, since he retired, he has not written a book as he thought he would, as Justice Stevens did when he retired, and he has not sat on lower court cases as some of his predecessor retirees have, Justice O'Connor, Justice Souter, to name two. I think he was ready to retire. Now, there is a whole nother narrative about Trump forcing him off the court by saying, I'll name Brett Kavanaugh if you leave. I don't discount that tale, but I do know, in observing Anthony Kennedy, that I do feel like it was time for him to leave. So it could have been several things coming together. And Don McGahn, whose name we've already raised once, Don McGahn certainly was courting Anthony Kennedy and trying to keep his fingers on the pulse of Anthony Kennedy and his retirement. And he was a tremendous backer of his pal, Brett Kavanaugh. So it might have been a couple things, but I do think, unlike Justice John Paul Stevens, Chicago's own, who managed to live and serve quite vigorously to age 90, it probably was time for Justice Kennedy to leave. Did you know him at all?
I did not know Justice Kennedy, but in one of his opinions, he cited a book of mine. I had written a amicus brief. It was a civil rights case. And Justice Kennedy, this had to do with the interpretation of the Civil Rights Act of 1866, a little obscure, but he said, I read Professor Foner's amicus brief here, and his position in it seems to be different from what he said in his book on Reconstruction. And in fact, he was quite right about that. And ever since then, I have not signed on to amicus briefs, because it's a different thing. When you're a historian, you're always saying, well, actually, yes and no, or maybe, and compromise. Whereas in a legal brief, you're absolutely 100% right. So Justice Kennedy taught me a lesson to be a little more clear about and honest in what I was saying related to the cases.
And maybe one piece of further context is when people think of Kennedy as someone who repudiated his past rulings by retiring at the time that he did, they're really thinking of the Casey opinion on abortion. And I think it's worth remembering that Justice Kennedy had many other areas of law where he made important contributions. And those contributions were largely on the right, not on the left. And so certainly with respect to questions of the authority that police have, certainly on questions with respect to federalism, certainly with respect to the questions of economic regulation and the power of agencies as opposed to the Congress or the president, Justice Kennedy was not a man of the left. And it's not unreasonable to think that he viewed more of his legacy being protected by retiring in 2018 than retiring in, let's say, 2014.
As a postscript, I think that's exactly right. In his very last term on the court, October 2017 into 2018, he was completely back in the conservative fold. He was with John Roberts, and they were just firmly on the right side, and he wasn't straddling the middle as he had done so many terms before that.
All right, your next question is down front and center here.
There's been some discussion about expanding the number of justices on the Supreme Court as a way to change the makeup of it. Is that realistic to think that that might happen at some point?
Well, who knows? Things have happened in the last 7 or 10 years that nobody predicted could possibly happen. The first thing is electing Donald Trump as president. To those of us in New York who had followed the career of Trump for decades, this was a rather astonishing thing, actually, considering.
But Eric, the size of the Supreme Court changed quite frequently in the period that your historical work covers.
The Constitution does not say how many people are supposed to be on the Supreme Court, and during Reconstruction, they they raised the number of people in order to get another vote on, or they reduced it when someone retired because they didn't want, it's happened. I mean, I think a lot of things that were not thought about, weren't considered realistic a while ago, ought to be at least on the table. Maybe not changing the number of justices, maybe an age limit. Now, of course, it would be hard for President Biden, given what his age is, to implement that. But an age limit or a term limit, 20 years and you're off, and that's what Jefferson sort of wanted. I don't know that we have to be stuck with exactly the structure of the Supreme Court the way it happens to be now. But I'm not knowledgeable enough about politics today.
I think I would say President Biden is against that. We've got really in Washington still, it's an institutionalist type of town. And I think that there's a fear that if you start at this point, after, even though the number of seats was as low as 5 and as high as 10, for the last 150 years plus, it's been at the 9. And the idea of expanding the number of seats just doesn't seem to be going anywhere, at least on the Hill.
And let me just add, just to build on something Eric said earlier, that if what your concern is democracy and concern about maintaining the democratic character of the national government, then it might be that expanding the number of seats on the court, it's a short-term fix, but it's neither here nor there. Because the reason that the court plays this outsized role in our democracy is that we have a House and Senate set up in such a way as to encourage stalemate. Our system of government is biased toward the status quo. And that means that for any given political coalition, it's really hard to get legislation through. And we see this time and time again, especially now that that national politics is more polarized than it used to. And under those conditions, of course, political coalitions will look to the court to do things that they can't do in Congress, like Dobbs overruling Roe. So the problem is hardwired into our political institutions in a way that I think expanding the number of justices is just, you're shuffling deck chairs on the Titanic, so to speak.
Wonderful. We have time for one last brief question, just down to your left.
Earlier you addressed the issue of grievance and Alito's opinions, and would you be willing to address that in terms of Justice Thomas, and particularly with two areas? He seems rarely to identify circumstances that would justify the reversal of a death sentence, and he seems to rarely, if ever, think that claims of race discrimination have been sustained, even in cases where other conservative justices have recognized it. He doesn't.
It's so true, I'll turn it over to Eric to finish up, but Justice Thomas really has rarely met a defendant he could side with, a little bit like Justice Alito on that. And his idea about any kind of racial remedies is that they are stigmatizing. And he's talked personally about his own experience, that he felt that because it was thought, and I think he's acknowledged that he got into Yale based on affirmative action, that he was always being second guessed about whether he was up to the task. So he has always felt that it was a bad thing for him, and that it scarred him in some way. And he had this line in his memoir about how he took his Yale law degree and affixed like a 15-cent cigar sticker to it because he felt like that was what it was worth at one point to him. And so he I'm sure we will see when the justices decide the racial affirmative action on campus case coming up, the one against Harvard and the University of North Carolina, that we will see him once again talk about how bad it is for society to have any kind of racial remedies for diversity on campus, or to, again, in the voting rights area, he has been consistently against any kind of racial classification that benefits.
Yeah, and as Thomas has become more and more influential on the court, he was a while, in the past, he was really considered an outlier, as you said. The conservatives were much more mainstream, but his views are now much more acceptable across the board. And again, it's an example of what I said before of what are the consequences. Thomas can say, oh, I kind of psychologically was injured by being admitted on affirmative action or something like that. But what will be the consequences for thousands or millions of non-white young people and others if the court, says, no, there can't be any racial remedies for past injustice? And they go back, they go back to Harlan, colorblind. The Constitution is colorblind, but not, that's not what Harlan was talking about in 1896. I think Thomas is, as I say, he had a personal experience, which you described, but to turn that into a legal doctrine for the entire country is, I think, it's just dangerous, frankly.
I believe that we're at time, and I believe that Joan will be available to sign her marvelous book, which you should go and buy, and have her sign after this. But before then, please join me in thanking both Joan and Eric.
Thank you. Thank you.
Oh, thank you.